Now we are going to study standard form of contract. Standard form of contract stands for there is a standardized form, like the form is filled up, the contents are there already, and it's standard for all the people. Like there is one party that has created a form and it will sign up many parties. So one party is signing many parties and it is giving the same form to all the parties to sign up. Like in the case of downloading an app, you get a user agreement. The same user agreement goes to other people as well. So all the people sign the same agreement or the same form. So the format or the content is the same for all the people. So and this standard form of contract, this is also known as boilerplate contract, contract of adhesion, and take it or leave it contract. Because you are bound by that form only, you need to agree to it, and if you do not agree to it, you do not have your own stance that you can present your own clauses or you can seek amendment in those clauses. You must take it or leave it. So either you are bound, there is a state of adhesion, or you have to leave it. So if you agree to it, then you are bound. So the situation of adhesion to that, because you have to adhere to whatever has been presented to you by the other party, and otherwise you must leave it, and you are not in a position to place your own words in the content of the contract. Now in this case, the position of both the parties or all the parties are not equal. One party is superior than other parties. Like in this case, we see when we download an app, the app company is superior because it is placing its own words, own objects, and own like clauses, and we must agree to them. And if we do not agree, we cannot download the app. We cannot say you make alterations to your clauses and we want something extra or something less than what they are stating in their contract format. So we cannot say that. So they are in a superior position. So this is an example of a standard form of contract or adhesion contract or take it or leave it contract. Now under these sort of contracts, it is also that the superior party does not allow any space to the inferior party, but there is no chance but to take it or leave it. The terms and conditions are placed by the superior party, like in the case of creating an email account, the email service provider places their conditions. In case of downloading mobile app, the mobile app company places its conditions, and the other parties using those services do not have their own stance. And the terms of the contract are drafted only by the superior party, and the inferior party must accept it as it is, else leave. Okay, the standard form of contracts are standardized contracts that contain large number of terms and conditions, and they are mostly printed in fine font that is difficult to read, and there is less spacing between words as well, as we can observe in such forms. Now and the clauses of those forms also restrict the liability of the superior party, because they draft all the clauses in such a way that they claim exemption from all the liabilities. Definitely you can go to the court, and if it is not legally viable, then they can state anything, but if it is not viable, then court will say that okay, you have placed a condition that is not enforceable by law, and it is unacceptable. So that is different thing, but at the time of entering into the agreement or the contract, you must accept such conditions that they are placing in their favor only, and you are getting no stand to place your own conditions. So this gives the party who is placing such conditions or placing such sort of form or the standard form or the standard format gets an advantageous position. They can exploit the other parties, and because they are weak, because they are only one and the company serves to many, so the one party whichever is downloading is in a weak position. If they unite, then they might become and if they work unanimously as well, then they might become stronger, but otherwise they are too weak because they are only one at the time of entering into a contract. They are not united, so the superior party, the company is the superior party in these cases. So they impose their own terms, which appears like private legislation, like they have created their own private laws, and they go to the extent of exempting the company from all liabilities under the contract. They force you to accept such terms that you are exempting the company from all the liabilities, and they keep everything in their favor. And when such cases reach the court, then courts find very difficult to come to rescue of the weaker parties. Now, statutory position on standard form of contract. Section 16 of Indian Contract Act 1872 cites unconscionable contract. Like they cite unconscionable contract, like where your conscience will not allow you to sign them, because both parties are not at parity or at equality. Some parties or one party is superior and the other parties are inferior, and they do not hold that advantageous position as the superior party. Now, with reference to contracts which are unconscionable, the unconscionable position refers to the position of the inferior party, that their conscience will not allow them to accept such conditions. And there is a situation of their undue exploitation, and under most of the circumstances they get exploited because they have no choice. They cannot present their own terms, and even if they move to some other service provider, they will also present the same sort of terms. They will exempt themselves from all the liabilities, and they will keep everything in their favor because the other parties are not united. So all such service providers unduly exploit other parties. So these are termed under unconscionable contracts, and the inferior party is under unconscionable position, where their conscience will not allow them to accept such contracts, but they get unduly exploited, and they must do if they want the service. And in these days you need some services, those are very necessary, and then you think, okay, let's accept it, we will see later whatever happens. So under those circumstances this happens. Standard form of contract versus Special Relief Act 1963. Now, Section 20 of the Special Relief Act 1963 deals with the court's discretion on decreeing specific performance. Like, court can issue a decree to perform something. Of course, this decree will be in favor of the weaker party and against the superior party. It can issue a decree, of course, to give relief to the weaker parties. But decree in favor of the dependent is at court's discretion, and it is not essential. Despite it might be lawful to give such respite or such relief to the defendant or to the weaker party. In most cases, the defendant will be weaker party only. The court may even abstain from issuing such decree in case of unfair contract. Despite the contract was unfair, court, if does not want, may not issue such decree. And as a matter of fact, courts are expected to not issue any decree under such situations or circumstances. Even if the contract was unfair, even if the too much hardship is faced by the defendant or the inferior party, and even if the contract was unequitable to enforce a specific performance, like there was no parity, no equality between the parties, or according to the content of the agreement or the contract, both parties were not treated equally. One party enjoyed superiority, and everything was in their favor. So it was not equal to enforce that performance of that contract, because when it is performed, it will be in favor of the superior party and it will go against the inferior party. So a superior party will gain advantageous position. Despite of all this, court may not issue a decree, and issuing a decree is at court's discretion, and in most of the cases courts refrain from issuing such decree against the superior party. So we should understand the pragmatic scenario in the court of law or in the legal ambit as well. Now section 19 of the Indian Contracts Act 1872. Section 19 of the Indian Contract Act 1872 provides or makes provisions for making the contract voidable at the discretion of the party, the consent of which was created by coercion, undue influence, misinterpretation or fraud. So if these were the factors influencing a contract, like if there was coercion or coercive means applied to obtain the consent of any other party, or if the party was unduly influenced, or if something was misinterpreted to the other party, or there was a scenario or a case of fraud, like if a party was treated by fraudulent means or fraudulent device, then the contract will not be valid and it will be voidable. So the party who is the suffering party, who is the victim party, can claim it to be void. So under those circumstances, the contract is voidable or will become voidable.